One legal requirement for making a will is that the testator be of sound mind. In Barnes v. Marshall, the court considered whether a testator's unusual beliefs and behavior were proof of an unsound mind or merely an eccentric personality. Dr. A. H. Marshall executed a will shortly before his death. Julia Barnes, his daughter, challenged the will, alleging that Marshall wasn't of sound mind when he executed the will. The case was tried to a jury, which heard evidence from numerous witnesses. Julia's husband, Ward, testified that Marshall told him that he had discontinued his medical practice at the Lord's command, that the Lord had revealed certain secrets to him alone, and that the Lord had given him special powers to mete out justice to those who had wronged him. Marshall also stated that he had run for Congress and the presidency on multiple occasions, and that if elected president, he would cancel all debt and kill all the bankers. Marshall spent thousands of dollars mailing out campaign materials, stating that the Lord had told him to do so. Marshall purchased a new car that he covered with biblical quotations and used to campaign. Frank Eves, a factory supervisor, testified that Marshall would visit the plant once a week and rant about the Lord visiting suffering on people. Sometimes Marshall would wear nothing but a nightgown. On one occasion, he exposed himself to a female secretary to show her a rash. William West, a drugstore clerk, testified that Marshall came to the store about once a month. Marshall claimed to talk directly to the Lord and stated that he should be Prime Minister of the United States. All three witnesses testified that Marshall would become highly emotional when talking, pounding his fists on the table, using profanity, shouting, and becoming flush in the face. A doctor who had treated Marshall opined that he had suffered from manic depressive psychosis for nearly 30 years. Another doctor concurred in this opinion. Numerous other witnesses testified to Marshall's unusual conduct and statements, opining that Marshall was of unsound mind. However, other witnesses testified that they believed Marshall to be of sound mind and that he was calm and collected when he executed his will. The jury found that Marshall was of unsound mind when he executed the will. Marshall's son John and other beneficiaries under the will appealed to the Missouri Supreme Court.